felt subject, but since 1989 there have been over 3,000 exonerations in the U.S., so we're hopefully going to get more, and we're going to talk about why we should care, how this happens, and then how exonerations can be achieved. And so we have two guests with us today, Professor Simon Singer and then Professor Stephanie Hartung. I'm going to turn it over to them to introduce yourselves and tell us a bit about your work related to law and wrongful convictions and the justice system.
Okay. Hi everybody, I'm Stephanie Hartung and I'm a professor at Northeastern Law School, and I also serve on the board of the New England Innocence Project. So I started my career as a public defender after law school, and I got interested in the innocence movement in the mid-90s when one of the very first cases I tried as a public defender, the first felony trial I ever had, my client was innocent and he very nearly got convicted. And the only reason I think that he didn't is because of the work of the Innocence Project that was already happening at the time. I was able to call an expert who could use some of the data from the Innocence Project to testify about how unreliable eyewitness identifications are, which I know we're going to talk about later. So that experience, when in my mid-20s, not much older than you all are right now, it kind of formed my interest in doing wrongful conviction and innocence work. And I currently supervise students who work with the New England Innocence Project and do case reviews and policy work. And my own scholarship focuses on wrongful convictions and also criminal reform procedure at the state and federal level. And in particular, again, a topic we're going to talk about in a little while, I think, but how difficult procedurally it is to undo a wrongful conviction, even with very strong evidence of innocence. So thank you so much for having me here. I'm very excited that this group exists at Northeastern, which I didn't know about before this event, so thank you.
Simon Singer, and also thank you for inviting me in this very important group. Prison reform is related to a lot of reforms that are needed in the system. I'm a professor of criminology and criminal justice, the School of Criminology and Criminal Justice, and my focus has been on youth crime and juvenile justice. So, my earlier work was on juveniles in the adult legal system, waiver laws, what were called decriminalizing delinquency, and that I would say got me into the hard end of the system, which includes the interrogation and the confessions that go along with that lead to a juvenile getting convicted in criminal court. And although it's not part of my sample, you probably all heard about the Central Park 5, so that would be a classic example. And they would not have been, it wouldn't have been the Central Park 5, it might have been the Central Park 1, but that's also rather dubious if it wasn't for a legal change that I had studied called New York's juvenile offender law, which lowered the age of criminal responsibility, bringing juveniles into the adult legal process. So that's part of my long-standing interest in this subject. I do have a lot of qualitative data, interview data, personal data with juveniles who committed serious crimes. And some of them didn't commit all the serious crimes they were convicted of. So maybe we can talk about that too, because we tend to think about innocence as something, as a thing that's either or, when somebody might be partially innocent. So I'm just putting that out there, and maybe you can help me in terms of what I'm writing about right now, which is the life course of some juvenile lifers. It's also part of a book that I'm working on called Adolescents Denied, Juvenile
first question, which you mentioned on. It's what, can you tell us what exoneration is for anyone who's not entirely sure, and the procedure that goes into getting someone exonerated?
Want me to start? Okay. Well, there's some disagreement in the legal community about what an exoneration technically means, and that, I won't go into all of those technical details tonight, but basically it's where there's a finding of factual innocence that accompanies a wrongful conviction. So a conviction can be overturned because of an error that happened in the trial, maybe an evidentiary error, or the DA argued something improperly, or the jury heard something that they shouldn't have, which may or may not have anything to do with factual innocence. But an exoneration is typically associated with factual innocence. So the two main resources, if you wanted to get a sense of how many exonerations there have been in the United States, there's the Original Innocence Project, which was founded by Barry Scheck and Peter Neufeld. It's in New York City. They maintain a very comprehensive website of DNA exonerations, so which I just checked it this morning to get the number, and there's currently been 375 documented DNA exonerations in the United States. And remember, DNA has only been used forensically in the criminal courts for the last 30 years, and really only commonly in the last 15 or 20. So, that's the number of DNA exonerations, but there are other kinds of exonerations that happen where a person's innocence is proven based on, it could be a recanting witness, it could be that forensic evidence that was used that was relied upon for the conviction has now been discredited. So examples of that are, bite mark comparison, hair microscopy, shoe print. There are all kinds of disciplines that we now consider junk science that were the basis of thousands of convictions for many, many years. So the non-DNA exonerations are also chronicled in the National Registry of Exonerations, which is maintained by University of Michigan Law School. It's easy to find online. And as of this morning, again, there were 3,060 known exonerations, both DNA and non-DNA combined, in that registry. And that number changes virtually every day. Someone new is exonerated. And just to give you an idea, just even here in Boston, I think I mentioned this to a couple of you earlier, there have been 12 men who I know of who've been released and either have been exonerated or working toward their exoneration just based on police misconduct in Boston in the last 5 years. So if you think about that, 12 people, just Boston alone, it gives you a scope of how incredibly large the problem is.
And then could you also talk about some of the reasons why wrongful convictions occur, like all the factors that play into that?
Sure, do you want to start, or you want to?
Well, I'm going to start based on my personal knowledge and what I've seen in the literature. First of all, there's the confession in the interrogation room. And, lacking evidence, physical evidence, convictions are also often based on confession, and how that's obtained. And the police use, and it's been disputed, and I haven't looked, what's the latest policies, but there has been a training manual that has emphasized minimization and maximization techniques, so that's out in the literature. It's a derivation of good cop, bad cop. So there's something going on in that interrogation room that's very psychological. It's a play on somebody's vulnerabilities, susceptibilities, and that one way to summarize it, that what's often going on in the interrogation room is the power of suggestion. Defined for the suspect, person in custody, there's there's a definition of the situation. We think you did this, we think you did that. There's a lack of sleep. So within my subject population, there's a known vulnerability, and that is adolescence and youth, combined with the stress of being in an interrogation room and being threatened with death, the death penalty. Although Roper versus Simmons, they don't know it at that time. So, so there's a lot of things that can go on, which would lead somebody to believe that they did something when they didn't really do something. So we're getting into some well-known psychological areas, and I think there's a combination of things going on too within the person who's being interrogated. One is you just don't think straight when you're in a hot state of mind, and so that could be going on. High stress, you're not thinking straight, and then I think generally we know this from the developmental literature that adolescents, children, are more vulnerable than adults. So that kind of explains the Central Park Five, that they were vulnerable to the power of suggestion, and they confessed to things that they didn't do, and they were even videoed. There's also what I've noticed in the history that's been related in now I don't want to take the whole time.
No,
so,
go ahead.
Okay. So that's in the history of some of my subjects. There's also, and maybe you could help me out on this, Stephanie. There's a kind of gray line between being a person of interest, where the police can question you and ask you questions about this and that, throw out things, and then being a suspect. Okay, so it moves from person of interest to suspect, and then saying you're under arrest, you're in custody. They don't even have to say you're under arrest, they're just putting you in custody, but they know, they're warned about this could be thrown out because of Miranda, so they give the Miranda rights. But by this time, you've already given them a narrative that they're just kind of confirming afterwards. And also, you're giving them, so this is where the minimization techniques come in, the good cop comes in. You've developed through this person of interest, we want it, something bad's happened here. We really want to know the story. You're not a suspect, don't worry. You really want to know the story. Here's some hot chocolate, some cake, come down. We just want information about what happened at Central Park, And, this is the good cop, maybe a couple of them. There's a trusting relationship. And then it comes to the point, well, we got to give you Miranda rights. We got to pursue this more. And at this point, you haven't had much sleep. You're a little stressed out about this killing that happened that you had nothing to do with. And, so I'm going to read you these rights, but it's kind of a blur. You have the right to Stephanie, an attorney. You have the right to remain silent. But, it's a blur, and it's a kind of blur that you're just signing away. And then they got you. There's no attorney, there's no being silent. So, based on my conversations in and what I've also seen in some of the transcript too, and confirmed, and also, this is a process that's going on. It's not a quick jump. Now I'm seeing it with adolescents, and the argument with adolescents that I make, it's not just me, this is in the developmental literature, so they're at a disadvantage. Adult authority, especially if they're innocent and they have no experience with the criminal justice system, so they're especially vulnerable. But I think we can expand it to adults, because a huge proportion of our inmate population, those people who get convicted, are not high on a cognitive scale. They haven't been exposed to criminal justice due process courses. They don't know their constitutional rights. They haven't grown up in a middle-class family where they learn to talk and to dialogue and to confront and stuff like that. So I don't want to, I'll say it, we're dealing with a population also that has significant intellectual disabilities. And they're not there, and they, Miranda is useless for that population. They just need an attorney there to be there,
Yeah, and I mean, certainly some who are interrogated have low IQ and, inexperience with the police or lack of education, but plenty of others do not have those things. And still what we know from the innocence movement and the DNA exoneration data pool is we know that for the moment I'll just take the 375 known DNA exonerations. And if we look at those, we know that 35% of them involve false confessions. So those are just indisputably, factually innocent people who confessed to a crime that they didn't commit. And it sounds illogical. It's hard to imagine that any of us ourselves would ever do that, yet it happens over and over again. And if it hadn't been for the innocence movement and this DNA, series of DNA exonerations that started in the 90s and continue to today, I don't think even now we'd have a clear understanding of how often this happens. But coerced confessions are just one cause. Some of the other factors that give rise to wrongful convictions are eyewitness misidentification, which I'm sure you all have had some exposure to, that we've learned again through this DNA exoneration data set, somewhere in the neighborhood of 70% of those factually innocent people had at least one, if not more, witnesses come into court, raise their right hand, and swear to tell the truth, and pointed the person out and said, that is the person who XYZ, I saw them. And they were wrong every time. And and so we know that happens at a much higher rate than we ever imagined. Another factor giving rise to wrongful convictions that we're learning more and more about all the time is flawed forensics. And we're learning about these disciplines that are now considered junk science that some of us spoke about a few minutes before the program started, including especially comparison techniques that were held out as science for decades. Taking two hairs, a hair from the crime scene and a hair from the suspect's head, and saying, this is a match, with no scientific method employed. I can tell this is the same person by looking at these two hairs under a microscope. There's no science behind that. Same thing with bite marks. There was a history of using bite marks on human skin, comparing with someone's own kind of teeth shape and size, and saying, yep, I can tell that was that person's teeth. Not science, just not reliable at all. That was used for decades. Shoe print, tire print, even fingerprint, while more scientific, there's a lot of questioning even about how reliable fingerprint analysis is. And so a lot of these disciplines have really come under fire and are no longer considered reliable in the courts, yet they're the basis of a number of hundreds, thousands of convictions that have happened over the years. So that's another factor. Another one is professional misconduct. So, government misconduct could be police, prosecutors, forensic analysts. With police, we have examples that are prevalent in the wrongful conviction cases that involve lying on the stand, coercing witnesses, hiding evidence, manufacturing evidence. On the prosecutorial misconduct side, the big one is what we call in the legal field a Brady violation. There's a Supreme Court case that requires, Maryland v. Brady requires turning over exculpatory evidence or any evidence that the state has that would show or tend to show the innocence of the defendant or would undermine a showing of their guilt in any way. They're required by the Constitution to turn that over. And yet over and over, we learned that didn't happen. And prosecutors rarely are held accountable for those transgressions, but they happen on a regular basis and contribute to wrongful convictions. The last one I'll mention is ineffective assistance of defense counsel. So you have the problem on the prosecution and police side, but it happens on the defense side too, where you have defense counsel who aren't adequately prepared, didn't do an investigation, didn't talk to their client, didn't meet with them and strategize about a defense in a meaningful way prior to trial, didn't call expert witnesses. So those are some of the main causes of wrongful conviction. There are others, but those are the most prominent ones.
And following back up on that, what do you think? Why do you think eyewitness accounts and confessions aren't always the most reliable resource?
I think the confessions one, Professor Singer talked about in some length about the reason why those tactics can be coercive with juveniles, but even with adults too. I'll say with eyewitness identification, we now have an understanding that the human brain doesn't work like a video camera the way we once thought it did, and it's very powerful when someone gets on the stand and says that's him, that's the one who robbed me, I'll never forget that face. But we now understand that there are things like transference that can happen where the case I mentioned when I first was introducing myself, my first felony trial when I was a young public defender and had an innocent client. It was a robbery and it was a cross-racial identification. And we later figured out that the woman who identified my client, she did recognize him. They lived in the same neighborhood and they had almost certainly seen each other around over the years, but not from the robbery. So that's called transference. That happens all the time. It's unreliable, but for years and years, the courts have been willing to accept this kind of testimony. And I'll just say, this is just true in a kind of across the board, that the courts are very slow to catch up to science. So what we know in the scientific world takes a long time to make its way into legal rules and procedures. And so we've known for decades that eyewitness identification is unreliable, but the courts are just starting to catch up and view it with more scrutiny, and same with coerced confessions.
Yeah. I want to add also to what Stephanie said, that there's stereotyping and there's typifying. So the stereotyping, I'm seeing in the news all the time, black kids committing these crimes, and okay, I'm a victim here, and it's a big blur, but it was a black kid, so that's sometimes I think the language is, it's not necessarily explicit bias, but implicit bias. It can sometimes be things that you unconsciously think about, like what's spinning in your head, who's the typical offender. So I think that's going on. And also, I use the word typifying, so how officials operate, how we all operate. We make decisions often based on experiences, what we think is a typical case. So police in investigating will often, and this is public, to the police, they have access to arrest records. I don't know if they have also stock, but they can instantly pull up somebody's profile and definitely somebody's convictions and stuff like that. So, they pick this stuff up, and then, hey, he's a likely suspect based on the past being a good predictor of the present and the future.
And then regarding DNA conviction or exonerations, how might someone's DNA evidence be missed the first time around in trial that can prove their innocence? And then also following up on that, is there any laws regarding the right to propose conviction DNA testing?
Yeah, well, so I'll start with that second question first. Massachusetts, just take a guess. Here we are in liberal Massachusetts, right? So out of all the 50 states, where do you think Massachusetts fell in line of passing a post-conviction right to DNA testing, to put it on the books in terms of our general laws? Just take a guess. You think we were in the first 10, first 20, first 30? Any guesses? 10, right? You like to think like we're Massachusetts, right? We're progressive.
How about the end?
Massachusetts was the 49th state. 49th state to pass. That only happened in, I think, 2013 or 14, and it was only when we got called out in a footnote in a Supreme Court case that it was us and I think Alabama that didn't have it. And then right after that, it passed in Massachusetts. And so we do now, anyone can get DNA testing after they've been convicted, and there's no real, although we do have DAs that will challenge it, but the law is very clear. You ask for it, you say it goes to my innocence, I'm innocent of this crime, and you get the testing. So that's the good news. In terms of why didn't the DNA testing happen to begin with, I mean, I have a case I'm working on right now from 1986. So there was no DNA testing that happened back then. So a lot of these cases are decades old, and they involve people who have been incarcerated since before the time of DNA testing. So it depends on, was there any kind of collection of physical evidence at the scene that might still have DNA, that might still have blood, or semen or hair or something that could still be tested all these years later, and often that is the case. Other times it's been corroded or misplaced or lost, and then there is no way to access it. But even in cases where there was DNA testing that happened, the technology is advancing so rapidly in terms of what can be tested that what you could tell 10 years ago from a sample, now you can do much more sophisticated analysis of. So like mixed samples 10 years ago you couldn't test, but now you can. A hair without a root you couldn't test for DNA, but now you can. There's all kinds of advances in DNA technology, and I'm not a scientist, so that's about all I can say about that. But that's there is an evolution of that kind of technology that continues to offer relief for people, even if it wasn't available at the time of the trial.
Yeah.
I'm a little naive about the DNA, but I do have a question as far as that. If I was a pretty organized criminal, and that includes being an organized criminal law enforcement guy, about the planting of somebody's DNA. Is there, I hate, and I just bring this up that I hate to rely on any one measure to convict somebody.
Yeah, I mean, there are cases that have involved planting of DNA, and that's been discovered post-conviction, and so it does happen, and oftentimes What we do in the post-conviction realm is to send DNA, send biological samples externally to a lab not affiliated with the government, because here in Massachusetts, the crime lab, while it's supposed to be independent, works very, very closely with the prosecutors, and so often we'll send to an external lab to kind of prevent some of that. I mean, that doesn't really solve the planting problem, but to the extent there's a question about the analysis. Yeah.
Law enforcement, corrupt police could be planting
Yep.
DNA.
Yep, there have certainly been allegations of that.
So why might law and like would police or prosecutors be reluctant to reopen a case that could result in an exoneration?
The $1 million question, why, right? Exactly. What, you know, it's infuriating that there's so much resistance, and I will say we've been fortunate in Massachusetts to have a so-called progressive prosecutor in Suffolk County, Rachel Rollins, who's an alum of Northeastern Law School, and was just made U.S. Attorney for the District of Massachusetts, which some of you may be aware of. But so there are district attorneys who will very intentionally and openly receive information about wrongful convictions and process it and try to do the right thing. There are examples of that happening, but across the board, what we're up against is this idea in the legal realm. It's called finality. The idea of just, this is the criminal justice system. We're the United States of America. We have 4th, 5th, 6th Amendment protections at trial. We have a jury system that's the envy of the world, supposedly. If someone's been through this system, they've been convicted, they've been through their appeals, we're not gonna keep reopening the case. We're not gonna keep relitigating after a conviction. That's the mentality that a lot of prosecutors have. That's the mentality that a lot of judges have. And I've never been a prosecutor, but I've been a public defender, and I know that it is fast and furious. You've got cases stacked this high on your desk every single day, and unless a prosecutor's office is devoting time and resources to someone to revisit these cases with evidence of innocence, like Rachel Rollins' office was doing in Suffolk County, no one has time. They're running off to court. They have a new stack of cases. They're not going to be reviewing, DNA tests that an attorney sends in from a case from 25 years ago. That case is done and gone in their mind. So that idea of finality that's weighed more heavily than fairness or justice is tragic, but that is often how it plays out in the criminal system.
I want to second that point, but also from the Stephanie pointed out the prosecutor's point, but also the innocent. They might take the position, and I know this from some of my cases, that I'll just do my time. I'll just try to get parole, admit, because I'm not going to get paroled if I don't admit and show remorse for an offense that I didn't do and take responsibility for an offense I didn't do. I'll play the game and I'll serve the time and just try to forget about it.
Yeah, and I'll just say I've seen the opposite happen too, where innocent people will pass up their chance at parole, who have perfect disciplinary records. They're eligible for parole, but they will not admit guilt, and they won't go through sexual violence training and the things that they're supposed to do to get released. They won't do it, and so they spend 10 more years in prison until they can get exonerated because they're not willing to admit guilt. So that's a real issue with our parole system as well.
Yeah, it's a big issue.
Yeah.
And then Professor Singer, this one's for you specifically, since you work focuses on juvenile incarceration, juvenile lifers, what would you say the big noticeable differences between the legal system for juveniles and adults, especially in regards to wrongful convictions?
Well, the population that I'm dealing with, they are in the adult system. That's the waiver, and they're, so in Massachusetts, in 1996, the Youthful Offender Act lowered it to 14. So, and liberal progressive Massachusetts had LWOP for 14-year-olds. So, life without. So essentially, there is a big difference between the juvenile and the adult system. Essentially, the juvenile system is the best interest, there's punishment there, but it's the best interest of the child that's dominating the rehabilitative, the treatment, however you want to call it, as opposed to determinate retributive objectives of criminal justice. So the police might, the police investigation could be the same, but there's less of an incentive because the prosecutor does not really have a place. It's not a public forum. So it's a whole different ballgame. And while I've dealt with the juvenile justice, that's very localized and very different depending on where kids happen to live. But once you get into a state violent felony and you're automatically considered eligible for criminal justice, then it's virtually, sadly, no different. And I don't know of anything in terms of what, there are stated requirements about a parent being called and stuff, but those are often, because the person of interest, suspect, arrest, they can be very gray areas, as we know from the Central Park 5.
Yeah. And then Professor Hartung, for you, so according to a 2021 report from the Innocence Project, innocent Black people are 7 times more likely to be wrongfully convicted of murder than innocent white people. Can you talk a bit about how race plays a role in the conviction, wrongful conviction, and then the Innocence Project's work to fight this disparity?
Yeah, I mean, so we know that Black and Latinx people are overrepresented in every stage of the criminal system, from arrest, investigation, conviction, sentencing, and then on the exoneration side as well. And I'll say that organizations like NEEP that I'm affiliated with and other innocence projects, many take an abolitionist approach and very strongly oppose the kind of foundations of the current police and criminal prosecution and prison system, and recognize them as historically connected to slavery, the legacy of slavery and slave patrols. And so, it's often said that our criminal system isn't broken, it's operating the way it was always intended to operate. And so if you think of it that way, it's not a surprise that we have Black and brown people overrepresented in this system. And so it's I think it's a recognition that once you get there, some of the reforms can feel a little bit meaningless, like tinkering around the edges of a system that's designed to oppress a contingent of our population. And so many who take on an abolitionist view are thinking about a more kind of radical restructuring and reimagining of the system that would be more fair and along racial lines, gender lines, et cetera. So that's, we're talking about a lot of different little reforms that happen around, well, do you have to video record an interrogation, or do you have to sequentially show photos in an eyewitness identification? And those are great steps in the right direction, but what our system needs is really a much broader kind of ground up reform as well.
And then, well,
Well, we can't, So those who come out ahead, you know, and I think defendants were lucky to have you as a lawyer with the public, as a public defender, but not everybody who's impoverished, as you pointed out, inadequate defense. You know, I would just like to add that racial divide is also one that is impacted by the localized nature of criminal justice from policing onwards. So in impoverished areas, there's more of a hard end kind of policing going on and a soft end kind of policing. And then, you know, you're talking in terms of diversion, more available to the middle class, you know, white middle class kids in, you know, Newton or affluent suburbs that you have in the inner city. So it's very, you know, to deal with this disproportionate minority confinement, whether it's in the adult prison or the juvenile system, it's very complicated, but, you know, if we could think not only in terms of the historical roots of institutionalized racism, but also in terms of resources to avoid the hard end of the system. So that's more in the white community, which is just, you know, less impoverished in terms of local areas and also in terms of individual or familial resources.
And then, so let's say someone's like finally got through all the steps, has become officially exonerated. What are their legal resources, if any, they have after, especially regarding like compensation and resources from the government?
So in Massachusetts, we do have a statute that allows for compensation for wrongly convicted people who have, you know, been exonerated and their factual innocence has been established. That cap was at $500,000 and was just raised to $1 million. I think 2 years ago. That's a Mass General Law 258D. So that's a relatively new change in that law. That's
a year, or is it?
No, that's a cap total. So this is not a lot of money. You know, we're talking, I mean, $1 million sounds like a lot to us, but not if you've just spent 22 years in prison for a crime you didn't commit. So it doesn't begin to make someone whole or compensate for the loss of their life, their livelihood, their family, their, you know, it's unimaginable. So the $1 million is just, you know, it's not meant to legally make them whole, but it is meant to give a little bit of a resource to just get your life started. But so in addition, the compensation law, you're entitled to without any showing of misconduct by the police or the prosecution or the court. It's just a blanket, you know, cap. But for those, often wrongful convictions do involve misconduct, as we've been discussing. So for those cases, you could bring a civil lawsuit in the state and federal court alleging misconduct on behalf of the government. And those cases, you know, you're alleging damages that are meant to more fully compensate you for your loss of life and liberty for all the time that you were incarcerated. So, you know, it really varies, and those are often settled out of court. And, you know, just as an example, a recent settlement in Springfield based on police misconduct was $22 million. So there's, you know, those are much more substantial, and those happen on top of the compensation cap that we have under the statutory law.
I don't think all states
No,
provide.
it varies by state, yeah.
And, but in every state, they can bring in a civil suit.
Yes, that's right. And I'll just add too, the New England Innocence Project has a new arm called the Exoneree Network, and it's led by Sean Ellis, who is an exoneree I think some of you are familiar with, who the Netflix documentary Child 4 is about him. He was wrongly convicted of killing a Boston police detective and served 22 years in prison. Sean now serves on our board at NEEP, and he's also the co-founder of this exoneree network, along with Ray Champagne, another local exoneree. And what they do, I mean, imagine coming out of prison after 37 years. I mean, you all haven't lived 37 years of life, but so it's impossible for any of us to imagine. But they don't know how to use a cell phone. They've never seen anything like this. They don't know how to use email or a computer. They haven't had a driver's license. I had a story from a friend who was exonerated after spending 19 years in prison. He went to get his driver's license and was told his license was suspended and he couldn't get a license. You know, there are so many barriers to just setting up a life. And even if you have, you know, many people who spend decades in prison, their whole families, they lose their families. Either, you know, their parents die, their siblings pass away, they never got to have children, and they come out without a support. You know, others are more fortunate to have family support. But so the Exoneree Network is designed to help give tech training, provide laptops, help with housing, help with employment, and mental health treatment. You know, imagine the trauma of going through this, you know, tragedy at the hands of the criminal system. People who sat at trial trusting that the government, they knew they were innocent, they were in court, and the government was going to come through and the system was going to work for them, right? The trauma associated with that is kind of unimaginable, let alone just daily life in prison. And so mental health support is a big part of that too. But that network is a big you know, move in the right direction in terms of supporting people after they're released.
Yeah, and I want to kind of follow up more on that. What are some of the collateral consequences of wrongful convictions, both on the individual themselves and like society as a whole?
And the families.
Yeah, it's kind of unimaginable the impact that it has. You know, people can be incarcerated far from their families, even in a small state like Massachusetts. And I don't know if you've ever been to visit someone in prison, but it takes a very long time. It can be a very dehumanizing experience, and so people get isolated from their families. And the other thing about wrongful convictions is that these are people, you know, I have people who are still incarcerated whose cases I'm working on now, who are just wonderful, brilliant people who don't get to be in the world. They don't get to be in society, and they don't get to interact with their family and friends every day and have jobs and you know, inspire other people and be inspired. And it's you know, so it's a tragic loss for all of us, not just the individuals and their families and their communities, but really for all of us.
Well, legitimacy is a big concept and an important one. And if you're convicting too many innocent people, it threatens the legitimacy of our justice system. You know, and that so you were innocent the first time, but the system sucks and it's terrible. And you tell your friends, and they don't believe in the system, and they don't report crimes, serious crimes, and you know, it can devastate whole communities. And I think that is the case. That's part of why certain communities reach the point of being so disorganized that their rates of violence are uncontrollable, because they don't trust the police to make reports, because they may be getting their brother rather than the truly guilty ones. So legitimacy is an important, sense of injustice is very important. So okay, I didn't do anything now, but now I'm going to get back at you and do something really bad. And especially I've lost these 10 years, and I'm in bad shape. You know, I've lost education. I've learned how to hotwire cars from ex-cons and stuff like that, and now I've developed a criminal network that I never had. You know, so we just don't want to go there. It has so many negative repercussions.
Yeah. We're running low on time, so I have one last question that I'll turn over for any pressing questions to the audience. But how might a student coalition like us enact change and fight against wrongful conviction?
I think we need to make the system more forgiving of those who are accused. You know, we have to really go out of our way to try to avoid the hard and determinate system. And you can do that by supporting not just general rehabilitative efforts, but efforts that target people who are disadvantaged, or for that matter, reinforcing juvenile justice. We take that there's a whole class of individuals who are vulnerable. So, and that means whether as reformed citizens or, you know, not supporting these hard-end, determinate, offense-based punishments that don't really get at, you know, and I'm not talking just the sentencing stage, from the point of contact, that don't really appreciate people's differences and vulnerabilities. So we're really talking about vulnerable populations and to make them less vulnerable. And I think that's an important part of doing good, is to try to equalize the playing field, and you're doing that through this organization and others.
Well, I'll just say there's a resource sheet going around, right? Do we have those there?
Yeah, I was gonna pass them out at the end.
Okay, so well, you can pass them at the end or pick them up when you walk out. But this is from NEEP, a kind of list of ways to get involved and things you can do from the New England Innocence Project. And I'll start by saying, you know, the first thing you're doing right now, which is you're learning, you're educating yourself, you're, you know, thinking about these issues. That's the first step. And the next is to amplify and share these issues. You know, once you pay attention to wrongful convictions, you almost can't open up the Globe. I know no one opens up the Globe anymore, but it gets a paper delivered. But you know, you click on the Globe or Boston.com, and without noticing a new story about someone who's walking out of prison today because of police misconduct that happened at the hands of BPD in the 90s. It's happening all around you, and just being aware of it, and you know, the fact that there's this group of you here today listening to us talk about this and caring about these issues is the first step. I know some of you have already been involved with NEEP and attended last year's Wrongful Conviction Day rally. There's going to be another one this year on October 2nd. And last year the rally was in front of the State House, had exonerees, families of currently incarcerated people who are fighting for their freedom, advocates, community organizers. You know, NEEP is works with a coalition of people in the community who are working to reform the system, not just to get the people who are innocent out of prison, but to reform the prison for everyone, to address the racial inequities that we talked about, and to reimagine the system so that it can promote justice in a way that it's not doing now and really hasn't ever done historically. So, you know, the other couple things I'll mention that are on the sheet as well are, following NEEP on social media, attending events. There's a fundraiser that's going to be happening in the fall, in November 3rd. I think the date is already set, but if you get onto NEEP's mailing list or follow them on, any social media, you'll get information about those events, and we really encourage you all to attend and get involved. So I'll end with that.
Great, thank you so much. Does anyone have we have 5 minutes left. If anyone in the audience has any questions?
Yeah, so you talked a little bit, well, okay, first I just wanna say thank you both for coming and speaking to us. This has been super informative, so thank you so much. But you mentioned, that beyond like the $1 million of compensation, people can file a civil lawsuit. How arduous is the process of actually filing this lawsuit, and how many people who are like exonerated actually go through with this and are given like closer to the actual compensation that they deserve?
Yeah, I don't have the exact numbers, but I'll tell you that it is, you know, like some post-conviction litigation that happens while a person is incarcerated is what we call pro se. You know, like if you've ever heard of federal habeas corpus, you know, you can file a petition to the federal court. When you're incarcerated, that happens often pro se, no right to counsel, you do it on your own, and there are kind of templates that can be used. But if you're trying to sue federally for misconduct of a government entity, you absolutely need an attorney. So it does take someone, you know, to connect with an attorney and to you know, move forward with a complex legal claim through a complex system. But I just anecdotally from people who I know who've been wrongly convicted and exonerated, the overwhelming majority move forward with civil litigation. I don't have the numbers on how many succeed, and oftentimes settlements are, you know, private, and there's a kind of non-disclosure attached to them, and so I don't even know if there are studies out there about those numbers. There are studies about the compensation part that doesn't involve misconduct, but the actual civil lawsuits are, you know, I don't know how publicly available that data is, but I would say most people do pursue it, and anecdotally in my experience, most get something. Yeah, not enough usually, but because it could never be enough.
Alright, well, good.
Also, thank you for coming. I know you talked a lot about like false confessions. You talked about like false testimonies. Are those things like on their own, like put in as evidence, or can they only like enact a trial, like it was a false confession or an eyewitness identifying who they think they saw?
I don't know if I heard the whole question. You said if they're on their own or?
Yeah, so like if like a false confession or an eyewitness identifying someone, can those like things on their own be evidence, or can they only like enact a trial?
They both come about through a trial. And either, you know, any case could have either one or both. And, you know, there are legal proceedings to challenge the admissibility. So you could, as a lawyer, if you think the eyewitness identification was suggestive, then you can file a motion to keep that out of the trial. Those are not very successful usually in my experience, but you can try. Same thing as if you have a client who gave a statement and you want to argue that it was coerced and it was an involuntary statement, you can move to have that kept out of the trial so the jury doesn't get to hear the confession. But again, difficult argument to make, but you can try that. And if you win, if your confession gets thrown out, a lot of times that's the case is over and it gets dismissed because you know, it just depends what other kind of physical evidence there might be, but a lot of times when the police are really leaning hard to try to get a confession, it's because they're lacking other physical evidence and they need the confession for a conviction. I don't know if that completely answered your question. Okay.
Then there's the appeal process too.
Right, absolutely.
So they can throw out the confession at appeal.
Yep.
Alright, well, let's give them a hand for.
Thank you so much, and please feel free to read, my email's up here. I'm at the law school. I'm happy to connect with any of you anytime, so thank you for being here on a Monday night.
Yeah, we'll send out their emails in our email following this, and I'm curious if any other resources you want to send us to share, but we can also do that as well.
Yeah.
Thank you so much.
Okay, thank you. Have a good night.